Alright, so I want to address an issue real quick and a solution to an issue. And this is related to contesting and disputing and denying certain traffic citations or citations in general. Now, in general, on a citation after it's issued, it gives you the option to either accept and pay or to contest. Now, you can contest in person or contest by mail. Those are only two options that the offer gives you. But just because those are the only two options that's presented to you, doesn't mean that those are the only options available. That being said, there's a third option that they do not want us to utilize, which is an administrative process. That option is called trial by written declaration. Now, as I've just found on the Superior Court of California, County of Orange. Now, the reason why I'm looking for this is because I'm researching the structure of certain motions and another way to submit the well, not submit, I don't like using the word, but to give notice of the trial by written declaration to the clerk of the court. Because I just recently got done dealing with a court case, which I almost forgot about, so I didn't have time to do my administrative processes, which sort of obligated me to actually go to court in person, which everybody knows I do not ever plan on doing at all ever in life. But considering the timeline, I passed the timeline, and I pretty much got to suck it up. And the whole purpose of me going in was to just play the fool for a second to establish a new date, to avoid any unnecessary warrants and stuff like that being issued. So that was my intent. Now, of course, when I first sent in my notice by my appearance, my special appearance notice, because when I first attempted to address it, I did address it in due time, but my documents were stricken from the record. So that's when you have these small local jail facilities that are operating as courts. So they're calling themselves a misdemeanor court, and the judge, everybody does what the judge says. She calls herself, calling all the shots. So she's playing the role of secretary, judge, treasury. She's playing a role of everybody. She's doing everybody's job, which is against the law. Now, when I look at the my court summons that came from the court, I clearly see no judge signatures. All I see is the actual clerk, which the clerk of the court signs off on everything. Everything, whether it's coming in or going out, is always going to be passed through the clerk. So the judge is operating outside of her capacity. So I have to prove that. So since she has the actual clerk representatives, because those are the people that were by the window, they didn't know anything about anything, but they knew what I was saying was true. It's like they knew it, but they wish they could say it, but they couldn't say it. So they know I need to get my documents on the record to reflect the proof of the facts of the matter, which will prove up under penalty of perjury, which will put the judge and the so-called peace officer in a position where they would also have to place truth and facts on the record and proof of jurisdiction under penalty of perjury. So that being said, I have to go outside of the box of what they're presenting to me, what they're saying, and I have to find other measures to do what I have to do for this particular case. So basically, I have to restructure my notice, because the initial notice was in a declaration affidavit format, the traditional affidavit declaration format. So now I have to tailor it to present it to be laid out as a court motion. Now, typically a lawyer would tailor up motions for court cases and stuff like that. But since us as private American nationals or secure parties, it is our duty to operate in the capacity and utilize our own personal private of attorney over our estate, some may say, or over our administration that has the same name as or similar name as the one we have. So I was doing some research. So I came up with this right here. So first of all, just to enlighten you guys on what a trial by written declaration is. So right here we have right on this website, submit a trial by written declaration. A trial by written declaration is a procedure where instead of appearing in court for a trial on your citation, you mail or bring in a written statement on a trial by written declaration by explaining the facts of your case and why the court should rule in your favor. You are entitled to a trial by written declaration. Your request by trial by written declaration must be made in person or in writing. Always try to do your delegations between the courts in writing. So bring that third party witness inside of the situation. The post office. Always bring the post office in the middle of everything by way of certified or registered mail and return receipt. Now, that way it cannot be ignored. Now, you are required to deposit the bail amount at the time of your request. Upon receipt, the court will mail you written instructions. You may also include any documentary evidence you may feel is helpful. So, if those of you that have your bonds in place, your fee schedules, your reservations of rights, your writs, anything, your affidavits, your declarations, all those things that apply, in general, should be submitted. But the first document should be laid out and structured in a way that the court cannot resist or deny or reject or strip from the actual case. So the officer who issued the citation, also the thing about the trial by written declaration, this puts, like I said, this puts the officer, the so-called person that made the claim, and also the person that makes the claim can't be the witness as well. But what the courts try to do is make the officer come in as a witness to the the situation, which is not lawful. So if he's making a claim, it needs to be another third party that has witnessed what the officer is saying, just in general. So, and also the court has to admit or say for the record that, hey, they actually have a claim against you. Does the state have a claim against me? Judge, do you have a claim against me? Persecutor, do you have a claim against me? If there's no claim, there's no case. All right, so this forces the officer who issued the citation to issue a statement or a written statement. You must waive your rights to appear to testify in person. But see, this is the thing. You want to waive your rights to appear in person that's not waiving it. That's actually preserving your rights, because once you appear in person and board that ship, you're waiving all rights you had to even defend yourself in law, right? So now this is the form that this is a structured form. Now you can easily write up something like just a simple document and a paragraph just saying like, hey, I, John Doe, am submitting this to issue out or to request a trial by written declaration, and get that notarized, submit that to the court. That'll work. That's worked fine for me, no problems, except dealing with this particular state court, misdemeanor court in Indiana. So these smaller courts tend to operate outside of their capacity because, I don't know, they feel like they can get away with it because nobody's challenging the property. So here goes the instructions for the defendant for trial by written declaration. Here goes the vehicle code. Now, the Vehicle Code Section 4902 allows the defendant to contest citations in writing without having to make a personal court appearance. This procedure is called trial by declarations. Trial by written declarations are available in cases involving infraction violations of the Vehicle Code or of local ordinances adopted under the Vehicle Code. The following instructions tell you how to obtain a trial by written declaration. So it says completely fill out the request of trial by written declaration, form TR-205. All right? Return the completed signed request by written declaration and pay the required bail amount, blah, blah, blah. You ain't got to pay none of that, though. Trial de novo. You need to research that. Now, within 20 days after the court's decision will be mailed to you. So this will work as your actual appearance. So those of you that can appear or notice you shouldn't be trying to appear in court. Now let's go check out the form. So this is for California. Now, notice where it says form adopted by Judicial Council of California, January 1st, 1999. We also have the power to amend and adopt documents for our personal behalves. So that means if you're in another state, this needs to be amended. Amended and changed to for that particular state. So I will put, of course, people of the state of Indiana. Or actually, no, it would be what they said on the summons. So it would be state of Indiana in my case, right? And then I would either amend or I would simply block that out. You know what I'm saying? Whatever, because that doesn't apply. So you just fill all this out, and it says the evidence. Now, the evidence is everything thereafter. The declaration, the trial by written declaration form. So this would be the top form that we will use, and everything else would go behind it. And we would check the letter H as other. So up under here, we will put Exhibit A, B, C, D, etc., etc. So Exhibit A might be affidavit or declaration of reservation of rights. B may be silver bullion bond. C may be declaration of solvency. D, you know what I'm saying, and so on and so forth. So everything else is listed as exhibits up under the main title document, declaration, trial by written declaration. Now another thing I've seen that these smaller courts are doing, or jailhouses are doing, is they're not allowing people to put things on a record. So what I'm gonna have to do with this case is go over their heads and go down to the main county court and place all these documents on a record, and then I'm gonna hire the clerk of the court of the county court to submit these documents directly to the clerk that I have the issue with, the clerk of the court where I have the issue with, by way of certified mail return receipt, right? So now I have two people in the middle, right now, instead of one third party. So now I have the other clerk, I have the clerk's hand, and I have the post office in the middle of it. So round two, I'm stepping it up full-fledged now. It's going to be no denying this, and I'm going to structure it as I'm going to issue it in the same structure that you would in a regular motion for a case. Therefore, they cannot deny it. All right, y'all. So that's pretty much it. I just want to keep y'all on deck on this stuff right here. This is how you're supposed to address court matters, or one way to address court matters, especially dealing with citations. Without going to court, because that's the last thing you want to do. So, peace out. Now, I'll probably have a link to download these or whatever inside the description. Make sure y'all follow. Whoever's not subscribed, subscribe. And if you subscribe, make sure you hit that bell, because I've been getting a lot of emails about people not getting notifications of my new videos when I upload them. Because Facebook is deactivating the alarm buttons on a lot of my subscribers, so they don't know when I'm posting. So make sure you guys have the bell activated on the channel.